Yes, you can start.
Yeah, thank you. On behalf of Nivaaran, Mediator, Supreme Court of India, Singapore International Mediation Center, and Commonwealth Lawyers Association, I welcome each one of you, all our august participants from different parts of the world. Good evening, good morning, namaste, and good morning to each one of you. Thank you for joining us. Your presence in this fourth lecture of fourth International Virtual Mediation Summer Camp, which has been uniquely conceptualized and executed by none other than our dynamic Mr. Santhan sir, Rajiv Datta sir, Aruneshwar Gupta sir, Mr. J.M. All of them have really thought of something very unique, wherein a learning has no age. They believe that learning and learners have no age, and the presence of each one of you is clearly depicting the belief which is by the founders of this association. So we have already, in this series, we've already gone into 3 classes, 3 sessions and lectures, which commence from 23rd, and we'll have it till 1st of August. Today, we are here for the fourth lecture, which is about communication and mediation. And we have our distinguished guest faculty, a legend, I would call him as a legend in mediation, Professor Andrew Goodman, who will be speaking to us about communication and mediation. So before I give him the floor and introduce about his qualities and qualification, I would like to just share my perspective on communication. I'll be taking little time because of the time inconvenience and change of guard and timing. We appreciate that a lot of you have your own commitments at family and work. So we'll try to make it as short as possible. The session would run for almost 75 minutes, wherein Mr. Professor Andrew would be taking 30 minutes for the topic, followed by 15 minutes of Q&A. And then we may have some I'll be taking some introductory part of it. So this is how the whole session would be running into 75 minutes, distributed into different categories. So, dear friends, I feel that today we are having, I think, the most important topic of the mediation. We have gone through the historical perspective of the dispute resolution day one. Then we had the conflict resolution management and resolution, by wherein our very senior Mr. John Bessie shared about the skills, the reasons behind this. And then we had the mediation process, also the definition and difference between the other ADR by Madam Diana just yesterday. But today I feel I may be little, I can say this is communication is something which is very dear to my heart, because I feel that in our life, no minute of our life goes without communication, be it with self, be it with others. And it is the lifeline of our relationship with others. A relationship without communication is just two people. Can you ever think of a minute wherein you are not communicating with yourself or with others? It is the most strongest adhesives, to continue into any relationship, be it business, marriage, friendship, any profession relationship is based on communication. Good communication can definitely bring in a lot of good things. Bad communication can destroy a lot of good things. This is what I believe. And in mediation, the only tool, the only thing which is at command of a mediator is process. And to run a process cannot be facilitated or commenced or can be carried forward progressively if mediator is not equipped. He or she doesn't own the requisite communication skills, because to be a facilitator between two warring parties, first he has to have certain skills wherein he can imbibe the information by himself. Before understanding the problem, he cannot be a conduit between the two parties who are already not in healthy communication. When they approach mediation, we know that the parties, they are communicating with each other, but that is not healthy communication. It is insensitive communication between them. And to rebuild that healthy, good emotional communication between the parties, a mediator himself has to possess certain qualities for himself or herself. And what are those qualities? Our guest faculty would be sharing with us. We have to just see as to why we communicate those W's we generally in mediation, we keep sharing. So why we communicate, how we communicate, where we communicate, what we communicate are the things, which are very, very dear to our life. And we always keep on saying, maybe at the cost of repetition, this is a life transforming skills, which we learn from these summer school classes, which Nivaaran has commenced. We ourselves improve in our communication with our other friends, with our relations, with our professional acquaintances. So, dear friends, today please make the best use of all the insightful things which our Professor Andrew sir would be sharing with us, because without which I feel a mediator without good communication skills, tools, cannot facilitate the communication, understanding between the parties. So please first equip yourself with verbal, non-verbal. We know that, as Mr. Aruneshwar was also telling about body language, and also there goes a lot of things in communication, not just words. The power of words, we know how to use words, it has powers, but sometimes without words also mediator has to facilitate the process, because to be a listener you have to be quiet, but you have to be present there. So that includes, you have to see what is being said and unsaid. So how would you take that all in to gather the information to understand the problem? Because day before yesterday, we had a class on conflict management and resolution. So to go to the conflict, we have to first go address to address the conflict, we have to go inside the address of the problem. And the problem, the reasons for the problem, we have to communicate with the parties as to why they are in difference with others. What are their needs and interests? So everything, every word, every needs communication. So we are right now, what I'm talking to you, what I'm sharing with you, my thoughts, it's all communication. It's a better form of conversation. So this is a beautiful thing. We'll be learning something new. Every speaker has some new perspective on a topic. So we are really blessed that Nivaaran chose Professor Andrew Goodman today for this topic of the day, which is communication skills for the mediator, non-verbal and verbal. And now, before giving the floor to Professor Andrew, I would briefly like to share his really incredible qualifications, which we must know before we invite him to share his perspective on the topic. So our distinguished guest of the day, Professor Andrew Goodman, he is an award-winning thought leader in the field of mediation and mediation advocacy. He is an independent commercial barrister with 45 years of experience, an international independent consulting mediator since 1993. He practices in up to 20 jurisdictions as mediator, an IMI mediation advocate, AppCam International Certified Mediator, trainer, advisor, and consultant. Andrew holds a number of visiting academic posts and advises government, bar association, corporations, institutions on conflict avoidance and dispute management systems. He is master of the bench of the Inner Temple and a distinguished fellow of the Internal Academy of Mediators. Andrew is the director of UK College of Mediators, convener of the Standing Conference of Mediation Advocates, director of the Association of Mediation Assessors, Trainers and Instructors. He is a faculty trainer for the Chartered Institute of Arbitrators, lead trainer and an assessor to ADR Group, United Kingdom. Andrew is a senior mediator at Joint Mainland Hong Kong Mediation Center, the Nepal International ADR Center, Oakville Mediation Center. He is senior international mediation expert of the International Dispute Resolution and Risk Management Institute. He is member of the Board of Advisors of Practice Fort Singapore. He is the author and editor of nearly 50 books and 12 journals, including Preparing for Mediation, a guide for consumer, Effective Mediation Advocacy, a guide for practitioners, contributor of a chapter on evaluative mediation and mastering commercial mediation, Ridgewell and others. And he has also contributed a chapter on Nepal to the Asian Mediation Handbook. author of How Judges Decide Cases, which is a very unique one coming from a mediator. Reading, writing, and analyzing judgments, effective written advocacy in practice. These are the few books which I have named, but he's authored, as I've shared with you, 50 books and 12 journals. So there is huge things which we can learn from his books. So I would recommend that we should go and read his books also to know him better, and just to be somewhere near wherever whatever he has he has learned and he has shared through books. We would like to, just further pass it on to the next generation. And today we are blessed to have him as one of our guest faculty for this topic, which is communication for a mediator, non-verbal and verbal communication skills. So over to you, Professor Andrew Goodman. The floor is yours. Thank you so much.
Thank you very much. There we are. So, distinguished guests and members of Nivaaran and the Singapore International Mediation Centre, fellow mediators, colleagues and friends. First of all, I need to thank Santan for the very kind invitation to give me the opportunity to speak to you this evening. I apologize for putting you out of the normal sequence of speeches and talks during the course of the summer school, but I've been involved in running a training course today, and I'm speaking to you from the Taj Hotel, but one with which you might not be familiar, the Taj Hotel in London, which is a very fine, fairly new hotel in Westminster. Also, I need to start by thanking Pushp for a very generous introduction. Sometimes I barely recognize myself from the way people describe me. I will be talking over the course of the time that we have together on some familiar themes. And I suspect that these familiar themes will be matters which you will have come across, which you will practice, which you will have been trained in, and which will, I think, understand as fairly simple ideas, because I do believe that simple ideas give us the best opportunity for learning. What I want to talk about today is to investigate the core skills of the mediator in communication. And I particularly want to investigate the way in which mediators are able to influence the parties without expressing opinion. This is at the heart of facilitative mediation. I don't discount evaluation. I think that even facilitative mediators are really evaluating all the time. I think that is in fact what we do, but there is a very distinct barrier in being able to express our opinion to the parties or even to their lawyers. And that is why we sit very comfortably at entry level with mediation through facilitation. In terms of the skill set that we use, nearly all of us, I think, are familiar with the lawyer's skill set. And I would have expected to see that the vast majority of mediators are either lawyers or retired lawyers, or have a connection with the law, or are professionals from other disciplines, particularly in the jurisdictions where that is permitted. In some jurisdictions, of course, mediators are only drawn from the legal fraternity. The lawyer's skill set, as I see it, or indeed the professional's skill set, is concerned firstly with critical analysis. We are trained to be able to identify, or often at great speed, the core issues between the parties, and more than that, perhaps the single issue upon which liability in a case is going to turn. If the case is worth more than liability and is really an investigation into quantum, we can also identify those core matters of significance, which are at the heart of what the lawyer does in determining a successful outcome for his or her client. Critical analysis enables us to take huge bundles of documents and identify with rapidity the material that needs to be used in order to turn the case. Beyond critical analysis, we are at heart problem solvers, particularly the litigators. We identify the problem which is thrown up at us, and we try and find the way to solve it within the confines or constraints imposed both by the law, the rules of evidence, and civil process. But it's the last skill set that we share with the mediator, and that is the skill set of communication. In terms of communication, we have an armory. We use language. We use words. Often I say to people that words are our business. And if words are our business, then we use words as precision tools. The use of English in particular is so rich that we can identify with great and very accurate precision the appropriate word to use in any given circumstance, whether it's in settling a dispute, having a managed negotiation, drafting a contract or a settlement agreement, or understanding and analyzing rights given within legislation. I believe that when I am mediating and when I am training in mediation, it is the power of words that are the nexus, the high point of communication between the parties. I understand process. I understand the underlying psychology with which mediators use language. But I think that for the purpose of outcomes, which I regard as my greatest successes in mediation over the last 30 years, it's the applied use of language, which is at the heart of being a successful mediator. And in particular, it is concerned with moderating the language of conflict. Lawyers are imbued with the language of conflict, which is a hard language, which is a language in English, which is born out of Norman French and Anglo-Saxon, and before that, some elements of Roman law. But the actual words that we use are hard words, and deliberately so. More than that, we use questions as weapons. If you think about the way trial advocacy operates, the orthodoxy of our adversarial training leads us to use questions as weapons. It is significant that the outside world regards cross-examination as questioning people by the use of some form of pressure. Whereas, of course, the reality is very different. The purpose of cross-examination is to secure an agreement with the question that's being asked. And therefore, there really is no point in trying to intimidate a witness into giving you an answer, when by getting the witness to agree to a much more modest and moderately framed and modestly given question, you can achieve the same objective. Mediation uses questions to bring parties together rather than push parties apart. And this is part of the transition of the role of lawyer within mediation. When I think about mediation advocacy, I am trying to make lawyers understand that the process in which they are engaged has to move them from the orthodoxy of their training, which takes them from competition, contest, to a state of cooperation, and from a state of cooperation to a state of collaboration, and from a state of collaboration to a state of creativity. The mediator is responsible for managing as much communication as is necessary to move the lawyers in that direction. And once the lawyers arrive at their destination, creativity, the mediator's work is almost at an end as lawyers take over and are excited by the possibility of generating options which allow for client gains, which they would not have envisaged before arriving at the mediation. So how does the mediator effect a communication which achieves sufficient influence to make parties move without expressing an opinion? How does the mediator engage the parties in option generation without imposing the answer himself or herself? Where is the added value that the mediator brings to a negotiation where the parties have already found themselves incapable of coming up with the answer themselves? I think the answer lies in the communication skills of the mediator and the way in which they are applied. I want to look at a number of areas, but I have worked examples which, although simple, overlap between the differing ideas in which the mediator is making use of communication skills. So fairly obviously, I want to talk to you about the power of the question. Secondly, I want to talk about the value of summarizing, refocusing, and reframing. I'm interested in silence as a form of communication and other aspects of non-verbal communication, sometimes called body language, but in fact, a good deal more than that if the mediator is operating on a proactive basis. It's my practice to commence communication substantially before the day on which the parties come together for the mediation. It's very valuable and a matter not to be wasted for the mediator to engage with either the parties or with their lawyers, if they are unrepresented, before the mediation takes place. And there are a number of reasons for doing so. It gives you the opportunity to lay the ground in terms of creating rapport. It gives you the opportunity of putting disputants at ease, because it's quite likely this will be an unfamiliar process and they will be nervous about it. So far as you are concerned, no matter how many times you tell the parties that you are not a judge and you are not acting in any judicial capacity, they will still think that you are some kind of a judge, and they will be worried about that. So the idea that you have the opportunity of speaking to them privately and in the absence of the other party and under strict confidentiality is going to enable you to advance the process even before the parties arrive on the day. Generally speaking, I issue my disputants, my parties, mainly because it focuses their attention on what the process is designed to achieve. And secondly, it's extremely important that when you're trying to engage in a communication where you're building a rapport, the parties have an idea of what it is you're trying to do. I don't believe in the mediation using the psychology of subterfuge in order to advance the process. I have much stronger ideas about transparency. Even though there is confidentiality attaching to both the process and the relationship between each party and the mediator and their professional representatives and anybody else engaged in the process, I think there is a place for transparency in communication, which becomes important in establishing the mediator-disputant relationship. One of the things that communication skills is essential for is to shift the focus of everybody's attention away from looking at the legal issues and trying to find a solution. Now, you may decide as mediator that it's impossible to move away from the legal issues, certainly at the commencement of the mediation. You may have a situation where there is, in fact, no ongoing relationship. You may have a claim where one side is effectively an insurer, and it's simply a question of what payment and when. You may have a claim which is essentially so legalistic that it is a managed negotiation which simply avoids doing the same thing at the court door. But invariably, where you have a relationship to try and preserve or transpose or reform, where the parties have an interest that is either financial or social or commercial or personal, in having an option which provides them with a realistic alternative to the court's remedy, then it's important to try and both get the parties' focus and for you to have some degree of effective preparation by the parties before they arrive. So, for example, I will send out a list of questions either to the party representative or to the disputant, depending on representation. And they are fairly standard questions, all of which you may very well have asked if you are mediators. But the impact, the effect of asking questions before the parties arrive is to communicate both your engagement and an understanding of what it is that they are required to do to prepare adequately for the mediation session. So I would ask things like, being realistic, what do you need to achieve out of the mediation? If you achieved this, what would it mean for you? And therefore, what do you need to do in order to achieve it? What do you need to say to the other party, either through me or through your counsel, in order to achieve it? And what you need to hear from the other side in order for you to achieve this? One of the most common questions that the mediator will be asking is, what is important to you? What is most important to you? What is important to you now? What is most important to you now? Why is this such a core question? Because invariably, when a lawyer that's representing a party sees that party, the lawyer engages on the basis that the lawyer has certain requisite information that he or she needs in order to run the case. The lawyer will have a clear understanding of what facts to draw from the client's story in order to give rise to an effective cause of action, or to understand the remedy the law provides, or to see whether there's going to be sufficient evidence to run the case, or how limitation fits in. various things that the orthodoxy of the lawyer's training will require them to understand. And therefore, when a lawyer is trying to establish what is important, really we're talking about what is important to the lawyer. And what is important to the lawyer to enable him or her to do their job may be very different from what is important to the client. And so as a mediator, I always draw a distinction in communicating with the client to ascertain what is important to the client and not what is important to the lawyer, what is important to the law, and what is important in the litigation. Because you're trying to move the client away from the litigation. And therefore, you need to understand the party's concerns. And this is before you get to interests. You may be lucky and receive sufficient information to enable you to formulate a picture before the parties come to mediation. But in any event, you're moving the process forward by asking questions of the parties before they arrive. Get them to think about what the other side are trying to achieve in terms of outcome. And get them to try and understand what happens if they cannot find a mutually acceptable solution. Because for the mediator, the next thing you want to do is to push the parties into thinking about their BATNA before they arrive. They may have a lawyer who's never heard of BATNA, who doesn't understand that it's necessary to formulate the realistic alternative of what happens if the parties can't come to settlement, in terms of time, in terms of cost, in terms of opportunity. And therefore, before the mediation, if the party is represented, I ask the party representative a series of questions. First of all, I tend to ask the parties realistically how much client expenditure is going to be needed to get to judgment from the date of the mediation if there is no settlement. And the next question is perhaps even more blunt. Can your client afford that? Does your client really intend to prosecute this claim to judgment? And that's something you need to be serious about. What are the client's likely irrecoverable costs? When is the trial likely to take place? My recollection of trial work in India is it does take rather a long time. What is the value to the client of his or her time? Not many lawyers know the answer to that question. And therefore, what is the opportunity cost to the client of either getting a settlement or not getting a settlement? Is there a better economic use of the client's time than litigation? Can you calculate what that is? And then, of course, a core question: is your client's present intention or present ambition to resume a relationship with the other side if possible? And if that is so, what is the likely value of the ongoing relationship? The corollary: what is the likely cost of fracturing that relationship by having ongoing litigation? What other factors need to be taken into account? They may be reputational, social, communal, neighborhood, cultural, health issues. These are things that you need to make sure that the lawyer representing a client, a disputant, knows as part of their preparation. The vast majority of mediations in which I have been involved, where the parties have not come to settlement, have really been to do with the failure of the parties to prepare adequately before they arrive. And also the failure of lawyers representing clients to understand what their function is. These are things that the mediator needs to communicate before the event occurs. The power of the question is, without doubt, probably the most important tool in the toolbox of the mediator in terms of communication. We use questions for all sorts of things, but if you just think about the way you communicate with people, the vast majority of people, when they first meet somebody, start their conversation with a question. How are you? And if I ask you to have a conversation with the next person that you meet, whether it's a partner or a spouse or a child or a work colleague, try this. Give yourself a minute and see if you can last in having a conversation without having a question in it. You will find it extremely difficult. And in fact, if I made that harder by saying you mustn't use the words I or me, I think you would find it almost impossible to have a conversation even lasting for a minute, because there would be no effective communication. You would be speaking at each other rather than with or to each other. The power of the question is the equivalent of having mortar between bricks when you're building a wall. And we shouldn't underestimate that. And we know as lawyers, of course, that there are 3 types of question that are available to us, or perhaps more. But if we focus on the difference between an open question and a closed question, the open question invites the recipient to provide information. That's what it is. It's an information gathering tool. And we use it in a number of different ways as mediators. First of all, we want to put a client at ease. We want to build rapport. One of the ways that you build rapport, of course, is to generate genuine interest in what the parties are saying. And you do that by the process, of course, which we call active listening. Active listening being another tool that the mediator uses, of which I'm sure there is sufficient training on every entry-level course in mediation awareness. Listening, to an extent, is almost as important as proactive participation. I have on my desk when I mediate, I have my name. I have my name in front of me. And I have to say that normally on the inside of my name tag on my desk, I'm not sure whether you're going to be able to see this, but generally I write this on the inside of my desk, simply as a reminder that, as Bill Urey says, we are blessed with having 2 ears and 1 mouth, and therefore we should be listening twice as hard as we speak. And that is a really good rule of thumb for the mediator, because listening is a form of communication. The mediator needs to be able to understand the dispute from both sides. You have to listen neutrally. Very difficult for a lawyer that's trained in critical analysis, because you will already be forming your own views about the value of the case, liability in the case, and you will be distracted by that. And active listening requires you not to be distracted and to find a way of assimilating and understanding and seeing things from that person's perspective in a non-judgmental way. It's difficult and it takes discipline. And I'm afraid if you happen to sit as a judge, as a deputy judge, or if you come to be a mediator after being a judge, you will find it even harder. But there, that is the way it is. So you're trying to be attentive and absorb and assimilate without giving anything other than expression of empathy. The very last thing that you must do is to agree or give the impression of agreeing with the person who's providing you with information. You must listen with complete, overt neutrality, but you must listen with interest. And we project interest in both verbal and non-verbal ways. So if it's culturally acceptable, we nod, or we make a sound. In my culture, you may do something completely different. I'm afraid I don't know. Maintain eye contact where it's culturally appropriate. Lean forward. Make sure that you appear engaged. And by the same token, don't appear to drift. Don't appear to lose concentration. Don't look at the clock. Don't look down. I know it's difficult because the mediator also has to make a note. But a positive communication is to say to the person, I need to make a note. Please excuse me. You're telling that person, I regard what you are saying as important. And therefore, it doesn't matter if you take the time to make a note rather than try and do it at the same time. Try and use an inquiring mind so that here you're projecting your inquiry into questions which are relevant because you're teasing out more information. You can do this with open questions, simple open questions. Tell me more. Please help me to understand. I need a little more detail. And engagement through communication is building rapport at the same time. And of course, as you build rapport, you're building trust. Nothing works in mediation without trust. That's why the projection of neutrality is so important. If the speaker begins to drift away from the point, you can use closed questions to keep them to the point. It enables you to control the conversation. Now, although I've said that I really don't like psychology by subterfuge, where the mediator is really manipulating the parties. And I do unfortunately accept, and I try and not to apply a pejorative sense to that word. I think what mediators do is manipulate, but they manipulate for good. They don't manipulate for their own purposes. So I think that not a small part of communication skills exhibited by the mediator is to maintain control. A good trial advocate maintains control of the witness in the witness box because they have prepared their examination in chief. They understand what they're trying to achieve in cross-examination. They limit their re-examination only to the vital matters. And the reality is they are in complete control of their witness. The mediator should be in control of the parties of both sides. There will be resistance from lawyers who are pushing back. But if you have built a rapport based on trust, then the disputant will be giving you information freely and may also be answering difficult questions, challenging questions. And once again, there is no harm in the mediator saying to the disputant, look, some of the questions I'm about to ask you, you may find challenging, you may find difficult. I don't apologize because I need to understand what is at the heart of your concerns. I need to test what you say is important. And you have to accept that the way I test is to ask you difficult questions. If you are faced with a lawyer that wants to intervene and say, please don't ask my client that, ask me, you have to make the lawyer understand that we are all there in order to get that client the best deal available. And this is the working method by which you do it. And that the client and the lawyer should both be using you as a mechanism to give effect to the best settlement that's available to him or her. And that's the way to break down resistance by the lawyer. And in particular, you need to make sure that the lawyer understands it's important for you to speak directly to the client and not always go through the lawyer. You need to ameliorate the lawyer's concerns, but it's very important that you have access, direct access, to use your communication skills with the client and not necessarily just with the lawyer. Tone of voice becomes important. For today and today only, even if you don't agree with that particular party, you are his friend. You are a friend to the lawyer because you're trying to help the lawyer do his job. For today and today only, the lawyer is being paid to get the client a settlement. Yesterday and tomorrow, he may be being paid to fight the case. But for today, he's being paid to settle. And if necessary, you, the mediator, need to remind him or her of that you're working together to the same end. The fact that you're doing the same job in another room for another client is neither here nor there. If there is a sufficient rapport and if it's built on trust, that is what it is that you are doing. So you inquire with open questions to obtain the information that you need. And an open question is really designed, firstly, in the first caucus, to relax the party into the process, and gradually for you to enter their world. I think it's extremely important that what the mediator is trying to do is to enter the world of the client, not stay within the world of the client's lawyer. Because the world of the client's lawyer is still the world of the case and the world of the legal box and the world of judgment. If you enter into the world of the lay client, the first thing you need to do is to moderate your language so that you don't use legal language. You're moving away from case and claim and defense. And all of a sudden, you're dealing with a problem in which there are challenges and issues and matters to discuss. You're not using submission. You're using conversation. And argument is discussion. And you are reframing your own words. Use questions to test understanding. And one of the most effective tools I find is to be self-deprecating. Please help me to understand. Why? Because as the mediator, I simply don't know until you tell me. I don't understand the detail. I don't know how your business works. I've never operated that business. Tell me more about your business. Tell me about your relationship. Tell me how the relationship started. Tell me about the times when the relationship was good. Don't you wish that a relationship could be good again? What would it take for you? What would you need to see? What would you need to happen in order for the relationship to come good again? Is this somebody you need to have a relationship with in the future? If so, please tell me why. Tell me about your world. What's important? You understand, I'm being slightly repetitive. but I'm only repeating for emphasis. So using questions to reinforce understanding is the next tool that we use. We talk about reality testing, but what we're really doing is trying to reduce expectation and trying to reduce ambition. Sometimes a mediator can be too abrupt in their attempt to reality test. And it may be that the key to this is to have a clear understanding of the BATNA, or WATNA or PATNA, whichever acronym you're working with. And trying to get the claimant to understand that his BATNA might not be solid. And trying to examine those areas of the BATNA which may come under pressure and may have to be reevaluated. So one of the core skills of the mediator in communicating is to make the client see his or her difficulties without undermining his position fatally. We tend to do this by reframing, but the way to do this in reality is summarizing. One of the core communication skills of the mediator we teach is reframing. Reframing, it's easier to explain than to do. It's actually a very difficult part of the mediator's communication skills. What you are trying to do is to reposition the client's thinking. I've talked about the moderation of language. And we start reframing language in some of the ways that I have suggested. But reframing can be done effectively in two other areas. The first is focus, getting the client to focus on things that he hasn't thought of before. We know as mediators that because of the legal process, the client has been persuaded to look at the problem from the viewpoint of legal rights and the potential legal outcome or determination of a case. But if we can get the client to put that to one side, we want the client to look at the bigger picture, the wider view, to have an understanding of the relative importance of this problem in his life to the rest of his life, to the rest of his business, to the rest of his family concerns, to his broader future. And therefore we reframe to change the perspective of the client on both sides. For those of you who are interested in photography, there is a very good analogy here. So the client is looking through the lens of the camera. The aperture is narrow. If you widen the aperture, the client is going to see things that he hasn't seen before, or that he hasn't considered that are important before. Mainly because he's been told by his legal team, that's not important, it's not relevant. It's not relevant to the lawyers, but it may well be relevant to him. And this idea of communication by making him see a wider perspective is something that the mediator does. Often, I use a flip chart to do this. I like the use of a flip chart. I like the use of materials. I like to get clients to draw diagrams. I like them to get engaged in the process so that rather than sitting at the back of a court behind a lawyer listening to what's going on. Get the client to be proactive and engaged and offer explanations about how options can help their business and what he's looking to do in the future and how coming to an agreement with the other side might enable them to do that. So I think that this is where the mediator is becoming proactive by the use of reframing. Now, for those of you who are still unfamiliar with the concept of reframing, I'm keeping one eye on the time push, but I still have quite a lot to say. Actually, I'm happy to speak for another couple of hours, but you'll tell me when to be quiet. So for those of you who are really unfamiliar with reframing, a frame is simply a cognitive point of reference. It's almost a shortcut to the way we think about something. And it's a lot of it's to do with our upbringing and our values, the value judgments we make about people and situations and things, and therefore the way we interpret things. And for the purpose of dispute, the way, in fact, that both parties might be looking at the same thing differently. And therefore, the job of the mediator is to get the party to communicate their own view of the other side's perspective. So one of the skills in reframing is to force the client to try and look at the thing from the other side. Yes, it is similar to NLP. Absolutely. Thank you. Thank you, Desiree. There are familiarities between this and neuro-linguistic programming. And I know many mediators who are also NLP advocates and professional practitioners in NLP. If any of you are interested in chess, take the opportunity of standing up and going around and looking at the board from the other side. And you'll discover that you're going to be mated in 3 moves. But don't tell that person, because he may not have realized that. And then you come back and look at the thing from your side. And reframing is an opportunity to get the client to be able to do that. Now, I say that you do that with words. I say that you convert the way in which the client is thinking about things by the impact of your summary. And you say to the client, so what you're really saying is this. What is really important to you is this. Have I got this right? Give the client the opportunity of correcting or changing it. But what you are doing adroitly is shifting his attention from his difficulty to his solution. After all, that's what you're there for. You are adding value because you are enabling him to see things from a perspective that he's not looked at before. So we're still in the exploration phase. The exploration phase starts with information gathering, in which you are asking these gentle, open questions. And as you need more detail, and as you need to be more directive as a mediator, then you move to closer questions, and effectively closed questions, and then questions which probe. And this is the sort of movement towards going from a fairly open view in terms of your communication skills to slightly more directive. Now, of course, there are 2 specific dangers that you need to steer away from. The first is you can never, by anything you say, give the impression that you agree with the other side. Very dangerous. And it's actually quite difficult not to slip into either an expression on your face or a question which suggests disbelief one of the things that a mediator always has to do is suspend disbelief. My favorite cases are fraud cases, where one side, or maybe both sides, are alleging that the other side have been completely dishonest. And therefore the case in law would turn on a fraud or misrepresentation. And the reason I love doing those cases is because mediation gives me the opportunity to suspend disbelief. And therefore, if you can do that effectively, you can convey to the clients on both sides that you're perfectly happy to accept what it is they're saying without agreeing. But the core communication skill which influences the building of rapport and the creation of trust and the driving of the clients towards option generation and refocusing, the core skill is the expression of empathy. We communicate most successfully when we are empathic. So Jawed has just reminded us that fraud is unfortunately excluded from mediation under the new mediation law, although it's hardly the law is hardly going to prevent one side from claiming that the other side has been acting dishonestly. So I'm not sure how you're going to police that. Where was I? Empathy. Communicating empathy is a core skill of the mediator. And empathy is an expression of understanding. So the mediator may say, I can see why this is a concern of yours. I understand why you think that. I can see how this makes you feel. It's obvious you're upset about this. Your hurt is evident. These are all expressions of empathy without tipping over into the sympathy of agreement and support. Sometimes I think that neutrality doesn't really help the mediator. The mediator, if anything, should be bipartisan. He should be partisan, or she should be partisan to both sides at the same time. Because as long as one party feels that you are inclined towards them in the help that you are giving, it doesn't really matter that you're doing the same thing next door in the other room. But I think that requires a degree of sophistication which goes beyond entry-level work. And you simply have to build up to that and have a great deal of confidence in what you're doing, because it's easy to make a mistake. Let me talk about silence. That's all right. I'd stop talking deliberately. Silence is a very powerful weapon, and in mediation, the fact that you stop speaking puts pressure on other people to speak. But silence can also be used as a form of empathy, in which somebody is upset, giving vent to their emotions, and you sit silently on the basis that that is a response which suggests that you're being empathic, that you're offering understanding. But silence can also give the impression that you don't believe someone. And it may encourage people to offer more and more explanation in circumstances where your rapport with them is put at risk. So you have to be very careful about the use of silence. And like good mediators, you have to know what you're using these communication tools for. And I mean be very specific about it. When you prepare a mediation, you should know what the questions are for, what it is you're trying to achieve. And once you've achieved it, move on. You should know why you are using silence so that you don't use it in the wrong way. You should be transparent about some of the communication tools that you are using, again, in order to keep the rapport going. So that if somebody is taken aback by a question that you have asked, or suddenly gets defensive, then the answer is transparency. I'm sorry, I need to know the answer to that to help me understand how to assist you. It's really what you're saying. And you can be even more transparent in the sense that you can be proactive. Look, I can see that this is a question which disturbs you. And I recognize that, and I am sorry. But we need to move together into a position where I can carry forward your concerns to the other side. I need to have confidence in what you want me to tell the others. So, thank you. Mrinalini has asked whether there is any difference in using these techniques, whether you're mediating live or mediating online. I think that mediating online presents a particular communication difficulty because, firstly, there is a slight time delay in communication. Secondly, you're only seeing the extent to which a person appears in the picture, which may be head and shoulders only. You may not get a full sense of bodily response when you're speaking to somebody. So you may be impaired in respect of being able to rely upon body language. You have the opportunity of seeing what you look like because it's a picture within a picture, which may actually be slightly distracting. But there is, I think, definitely a moderation of the kind of skills that you would use, which enable you to gauge body language and gauge reaction. The other thing, of course, is generation of energy. I'm one of these mediators who believes that there should be energy in the room. And to that extent, I'm very happy as a mediator to get up and walk around. Sometimes I actually encourage the parties to get up and walk around, and particularly where it's obvious that they feel under pressure. You want to try and get them physically to move, relieve tiredness. Sometimes I've even said, let's go for a walk around the block. Let's talk it out in the sunshine. You change the atmosphere, you change the perspective. And all of a sudden, once you're out of the mediation room, it feels much more like just an ordinary social conversation. And you may find that you're told something far more important than somebody would reveal in the course of the mediation. So I've been asked a couple of very interesting questions, which are now in the chat. And I can see the time is going much faster than I had anticipated when I started talking. And it may be more valuable to move on to questions. I'm just looking to see if there's anything that I need to say which I can't otherwise answer in the course of questions. I think there are two things I'd like to finish on. The first is the role of the mediators communicating skills in helping to develop options. So you've done your exploration, you've done your reality testing to reduce expectation. But having reduced expectation, what you're really trying to do now is to rebuild expectation by helping the parties generate options for settlement, which enables them to succeed in coming to an overall agreement. And once again, you can use open questions for this. How can you move forward from where you are now? So what do you think might work for you and the other party? Bearing in mind, there's no point asking for something which isn't going to satisfy the other side as well. We have to find something which operates to the advantage of both of you. Simply getting what you want isn't enough. Otherwise, all I need to do is to go next door and ask for the whole of the claim and the whole of the costs. And that will be the end of the mediation. So let's be proactive and let's be productive and let's be creative. What are you going to be able to do to resolve this? And are there things that we can try which the other side might not have thought of? And okay, so you don't accept that as an idea. Give me a better idea. What might work better for you? And remember, you have underpinning this, the safety net of the BATNA. So remind me what's going to happen if you don't get a deal today? And how long is that going to take? And how much is it going to cost? And what are you going to waste? So I think that you use open questions and then be specific, because remember, I said before, you have got to operate within the client's world, not within the lawyer's world. And that's why, as part of your communication, you need to encourage the party to give you an understanding of that world, how their business works, how their manufacturing enterprise works, how their business is financed, what the various commercial structures are, what the stakeholders are. Is there anybody else that's an influencer in the outcome that you're moving towards? What can you live without, and what must you have? Fundamental questions before you go into the negotiation. Now, the next phase and the final thing I want to talk about before I revert to some of the questions and look at the rest of the time that's available is the negotiation phase itself. What is the responsibility of the mediator in communicating offers between the sides? I do not accept that the mediator is merely a cipher that takes offers between the parties. And the obvious example is the opening offer. I think that one of the skills of the mediator is to identify who should make the opening offer. And normally you may think, well, it's going to be the paying party. But if you have a creative settlement, it may be that both sides are going to be doing something by way of exchange. And if you think about it, that's the most acceptable outcome that you can have in a mediation. So I think the mediator should decide who really ought to make the opening offer, because that sets the frame within which the parties are going to negotiate at the start. The most obvious situation in which a mediator is in trouble is if the opening offer is a terrible offer. It's a bad offer. You know perfectly well that if you are forced to take that offer to the other side, they will simply leave. And therefore, the mediator has got to make the offeror understand how the offeree is likely to react. So the fairly obvious question is, well, how do you think the other side are going to react to that offer? How would you react if you were in their position? Do you appreciate the risk that that might terminate the negotiation before it starts? If you insist on me putting that offer, then I will put that offer, but I will only put it at the time of my choosing. And you need to accept that. And then I will go next door and I will say, I'm very pleased to tell you that I have an offer for you. But I'm not going to tell you what the offer is. And the reason I'm not going to tell you what the offer is I want to understand where your starting position is. And I want to be able to gauge the differences, if any, between you. And that's my cop-out from having to put a bad offer. I'm not convinced that the mediator is obliged to put a terrible offer. I think that you have the power to manage the process in the way that you think most appropriate. And communication involves both bad as well as good. One of the things that we are very much concerned with is to offset the process that psychologists called reactive devaluation. I'm hoping that in your basic training as mediators, this is something that was explained, but for those of you who aren't aware, reactive devaluation is a bit like shooting the messenger. Somebody whom you don't like or don't trust makes you an offer. And that offer is devalued because you don't like and you don't trust the person that it's coming from. Now, that may include the other side, and that may include the other side's lawyer by extension. And one of the roles of the mediator is to absorb this sense of reactive devaluation. Why? Because the offer isn't coming from the other side. It's coming from you, the mediator. And therefore, you moderate the wording of the offer in circumstances where you have to reframe it. And even a bad offer can be dressed up to look reasonable, or at least you can change the context in which it's being delivered. So as a matter of communication, the mediator has a very important role to play in the course of the negotiation session. And I think that this is probably a good place to start, to stop and take questions, including some of the questions that are already in the chat. I do apologize if what I've been saying appears to be slightly disjointed and not even as built. But as you appreciate, this is a big, big subject. And I think that it's probably worthy of more than the time that we are able to allow for it. And I do apologize for those people who have got family and other commitments of an evening. And of course, it would be my pleasure to come back and speak to you on another occasion. So let me just finish there and move on to some of the interesting questions that I've already seen in the chat.
Thank you so much, Andrew, for this really insightful session. And I don't want to summarize it fully before we go for the question answers. But genuinely, the thumb rule which you gave us as a mediator, I would like to just share those two, which I have gathered from all the conversation you have made. That was, a mediator should have a knowledge as to when to use which communication tool. Not necessarily we have to use them in moderation. We have to be aware of the reasons, the purpose we want to achieve by using a particular communication tool. So that is where we lack. We simply feel that this has been taught to us by our trainers, by our master trainers. So let us use all of them. So the purpose we want to achieve really makes a lot of difference as to which one we have to pick up at a particular time, because to manage a conflict, to keep the parties engaged, so we have to be very purposeful. And another thumb rule which you showed us with that placard is shut up. So that certainly we all mediator, I would certainly put on my mediation table when I do next mediation. That is very important to be a listener, So thank you so much for this. So we'll go for, there are comments of appreciation in the chat box. So we'll go for the questions which have been put up by a few of our participants, our colleagues. So may I please help you picking up them from the chat box? Please.
Yes. So can you take the questions out of the chat box and just read them?
There are a few. One is, what is the difference between open and closed questions, sir?
So a closed question is suggestive of the answer. Normally, lawyers use closed questions in a cross-examination, and generally speaking, you're pushing the recipient of the question to answer yes or no. So closed questions tend to be much longer than open questions. One of the shortest open questions that I use is simply the word so. So I have a friend who always used to come back from the open session into the closed session, and the first thing he would say is, so? And open questions encourage people to speak for as long as they wish and to provide as much information as they wish. Closed questions focus on very specific matters that you want to know, and they encourage you to get the client to focus on a very narrow area of information and either provide that information in more detail or simply to answer your question, yes or no. Closed questions are generally used in probing and in reality testing. And you have to be careful. Sometimes when we use the word why at the beginning of a sentence, people can take that in a very defensive way, because sometimes the word why is used accusatorially, whereas where, when, how, what, and who are simply used inquisitorially. Sometimes, I mean, anything can be turned into a question simply by raising the inflection of your voice at the end of the sentence. Sometimes the most general of questions are the most telling. So, for example, just before you leave a room, you can say in an offhand way to the parties, is there something else? They may say no, but if they do tell you something else, you know that it's going to be very important. And you get a feel for when to use a question which enables people to speak and when you use a more closed question. Remember that closed questions can make people uncomfortable. When I do role play exercises in my training, we demonstrate the difference between open and closed questions. And I find that people can get very uncomfortable with closed questions, even in circumstances where they know that it's simply a role play exercise as part of training. They still feel uncomfortable. So you have to be very careful about the way you use questions, which is why I'm grateful to push for reminding people that you need to know why you are asking something. And of course, it's not a scattergun approach. Remember that the best question is simple. It doesn't contain multiple questions. And it should be quite short. When you develop a conversation, and I'm going to ask you to do this, literally the next person you speak to, which may be your children when you put them to bed, or maybe your spouse, just think about the structure of the conversation that you're having and look for questions and look for the difference between long and short questions and just see what happens within that relationship and within that the context of that conversation. And I guarantee you will find it interesting. And you will also, I hope, find it instructive.
Thank you, Andrew, for that response. We have one more from Dr. Kishore. Do high context and low context cultural backgrounds of mediators and the parties, their counsel, affect the pace and quality of communication in mediation?
I'm afraid they do. And I think it's self-evident that where you have a stratified culture and heritage within your jurisdiction, it's going to, with respect, be reflected in the level of education and therefore the degree of articulation of the people who are involved in the process. If mediators come from a legal background, the chances are they will have high education and they will have a degree of articulation which is superior to the client. The fact of the matter is, you need to leave behind the articulation that you're used to. You need to leave behind, where possible, the legal language, and you need to speak in the same terms as the client. You know, I always say to lawyers, you need to get off your high horse. You need to get your head out of your backside. You need to stop pretending that you're superior and clever to the people, more clever than the people you represent. Because in this context, mediation is trying to equalize. And there will always be a barrier. There will always be a distance if you maintain the cultural and educational stratification, which is normal to you. But that distance may hamper your work, I'm afraid. So I think the answer is yes. And I think the answer beyond yes is that you need to accommodate it. You need to do something about it.
Thank you. We have just one more from Mr. Vijay Kumar. Sir, does online mediation really work? He says, I don't think it works. Please advise.
Well, I'm sure there are many people on this call who are mediators and who mediate online. And during the course of lockdown, certainly in the United Kingdom, the mediators were forced to go online. If you didn't go online, you didn't work. And many of us who were very reluctant came to understand that it is possible to mediate online. It's desirable for many people who don't want to travel or who don't want the cost of the additional expense of room hire and having to pay for lawyers to travel. But it is different. The atmosphere is different. And I think that with respect, you need specific training in doing mediation online. When I mediate online, I refer to the technology as another party in the room. And you need, therefore, somebody who's a good deal more experienced in technology than I am to help you. I think it does work. I've seen plenty of occasions when it does work. But as in everything, there are horses for courses. Sometimes you already know that it will work better in person. Sometimes you may think there are good reasons for having it online.
Thank you, sir. That was a genuine response, because I feel during COVID, we all are into online learnings, virtual summer school, virtual classrooms. They're all impactful. Yes, there are few sessions wherein we feel that in-person learning makes a lot of difference. So online and offline mediation, the merger of two depends upon case to case. And something new which again we have learned is that yes, technology is another party in room. So you need a special ability to handle that. Thank you so much for this wonderful session. And I think now it's time for us to say goodbye and come back again for our 5th lecture tomorrow, which is on negotiation. And as Andrew has said, that we must ask specific questions before we disperse for negotiation. So just don't start negotiation without coming to a conclusion as to from where you have to travel and who has to make the first offer. And for this lecture on negotiation, we are again fortunate to have another very distinguished guest tomorrow, Ms. Sushila Sarthi, Senior Advocate and Senior Master Trainer, who would be taking up our 4th class tomorrow lecture, which same time, 5 o'clock, as written in the schedule, which we have already shared in WhatsApp group and various social media group. We'll again float it back so that there is no miscommunication. Communication is the topic of the day. So we don't want there be any miscommunication. So tomorrow again, we'll meet up and we'll keep our learning intentions on, and we grow together, we learn together. And thank you everyone. With special thanks to Professor Andrew Goodman for taking out time and giving us a very patient, impactful learning on this topic of communication. We are grateful, sir. Thank you so much. Thank you, each one of you. God bless you all. Good day, good evening, good night. Bye-bye.
Thank you, Andrew. Thank you, Push, for a wonderful moderation. Excellent.
Thank you, sir. Thank you, sir.